Hello, legal-minded friends. We have an update in the case regarding the Donna Adelson trial. We saw Donna Adelson, a 73-year-old grandmother, arrested at the airport. My guess is she hired Dan Rushbaum to represent her because he knew the case better than anyone, as he also defended her son, who was found guilty of conspiracy to commit murder, of her ex-son-in-law, who was married to her daughter, Wendi. If you haven't heard of this case, check out my playlist. The update is Donna Adelson's attorney, Dan Rushbaum, had to ask the judge to release him from representing her. This is going to delay the trial for potentially months. How could this happen? How could legal strategies backfire and go so wrong? Let's get into it.
So, how was everyone's evening last night?
Got a lot of sleep, Your Honor. How about you?
Slept like a baby. Let's start with the notice of invoking rights and non-waiver of conflict of interest by Mr. Adelson. Do you have anything to argue beyond what's in the pleading?
Your Honor, I'm not here to advocate for a position for the court to do something in this case. The only thing I intended to do with my filing is to invoke Mr. Adelson's rights, to put the parties in the court on notice that he does intend to invoke his rights.
Right.
So what happened? In a nutshell, a motion filed by Charlie Adelson's appellant counsel. They announced he was invoking his Sixth Amendment rights regarding his former counsel, Dan Rushbaum, who Donna Adelson hired. So originally, Rushbaum said Charlie Adelson waived attorney-client privilege for him to represent his mother, Donna. His appellant counsel disagreed that he ever waived his attorney-client privilege, and this needs to be addressed because he is at risk of the state calling him to testify, and he is not waiving his attorney-client communications with Dan should he need to cross-examine him. So we're going to hear the judge ask for the state's position in just a second. When a lawyer represents two clients that are co-defendants with the same charges, you need both defendants to waive their client attorney privilege. So let's continue.
Right. Ms. Kappelman, does the state have a position that it wishes to raise concerning the notice or the filing?
My only position, Judge, is that this issue has been waived. Your Honor did an inquiry which was thorough, covered the issue, and...
As to Mrs. Adelson.
Yes, sir.
Concerning Charlie Adelson, I believe, well, I don't want to get ahead of myself, but the only way Mr. Rushbaum's representation could occur is if both ends of the conflict were waiving. I don't believe Mr. Adelson ever took an affirmative position one way or another.
My understanding was he did, but I guess that position is changing, so I don't know. I have to defer to Your Honor on that.
Does the state intend to call Charles Adelson as a part of its case in chief?
No, he would be a rebuttal witness at this point. Now, that could also change too, but as of this moment, he is a rebuttal witness.
Ms. Niles, is there a reason that your client waited until yesterday to assert his invocation of this right and non-waiver?
Your Honor, I think the critical question is when the conflict arose. So...
Oh, the conflict has been there. The conflict is clear on its face. It's as clear as my nose. Is there a reason your client did not assert this until yesterday?
Your Honor, my understanding is that my client has not waived at any point. And so asserting it yesterday was merely putting the parties on notice of that non-waiver. I mean, the fact that he's listed in discovery as a Category A witness does not mean that the state was going to call him as a witness at trial. I think the conflict arose when my office received a subpoena for his trial testimony, which was last week on September 11th, and then he was transported to the jail on September 13th. Mr. Efferman was able to meet with him at 8 o'clock in the morning on Saturday the 14th. And then at that point, without revealing any confidential communications with our client, we became aware that all the parties needed to be on notice that there was no waiver and that he does intend to invoke his rights. And so our notice was filed the next business day, Monday morning. It was later in the morning, but we were trying to get it done. We were a non-party, so we were having some trouble figuring out how to get it filed, but we drafted it and alerted the parties and the court as soon as we knew that this was an imminent issue, that his rights were imminently potentially going to be violated. Now, I don't think, excuse me, I don't believe they would be violated until he takes the witness stand, and at that point, either his former counsel attempts to cross-examine him, or another member of the defense team attempts to cross-examine him, or they advance an interest that is materially adverse to his interest. So I think the potential for conflict was always there, but the conflict arose, it's going to arise on the witness stand. It has not quite yet arisen, but the potential for conflict.
It's simmering, not boiling.
Yes, Your Honor, it's burgeoning.
Mr. Boris.
So now the judge wants to hear from the defense team for Donna Adelson. Will they offer a solution? As this hearing is literally when jury selection was about to take place. Will the judge have to send home hundreds of potential jurors that were sitting, waiting to go through the juror selection process? Oh my gosh, can you imagine what they're thinking? What's going on?
I'm going to have the afternoon jurors report at 2 o'clock, so that way no one's time is wasted while we're going through these matters.
Now we're going to listen to the second chair in the defense team tell us about how he has been walled off from any client attorney privilege information that Dan Rushbaum would have had regarding Charlie. So let's have a listen to that.
Mr. Boris.
Yes, sir. Judge, when I came into the case, at the inception of the case, obviously I was aware of the fact that Mr. Rushbaum had represented Mr. Adelson. I was aware of the conflict, whether it's arisen or not. My view of it is that it's always been there and been present. As a result of that, I have been walled off from everything as it relates to any discovery from that prior case, any notes. I've not had any conversations with Mr. Rushbaum about Mr. Adelson's evidence or property. The first instance that I met Mr. Adelson was this past weekend on Saturday with Mr. Ufferman. And in fact, Mr. Adelson queried whether or not I had seen his phone. I said no. But we planned for this exact circumstance. And the idea was that I was going to conduct any cross-examination if Mr. Adelson were to testify. Mr. Ufferman's motion argues to impute the conflict absent a showing, a good faith showing of an ethical wall. I think that we've done that, but of course, as I mentioned in my response, we plan in the alternative if we're forced in that direction of securing alternate counsel.
When was the third-party counsel retained?
Candidly, there's been no retention in terms of money from Mrs. Adelson to that lawyer. That's prepared to happen. We wanted to see Your Honor's ruling. But the answer is I spoke with the attorney yesterday to confirm, just as I mentioned in the response, availability and absence of conflict for that lawyer.
All right. I've gone through, I believe, at least 2 Lazarley inquiries with your client, specifically as to this conflict that exists between his former client, Mr. Adelson, and his current client, Mrs. Adelson. Is there a reason the defense did not bring before the court that you were pursuing third-party counsel, or there was, in fact, no waiver from Charles Adelson?
Well, let me back up and provide the court some information then. So there was, in fact, a waiver with Mr. Rushbaum. Mr. Rushbaum consulted.
Verbal or written?
Both. There was a third-party lawyer, Mr. Moses, who was hired as third-party counsel out of South Florida to consult with Mr. Adelson independently outside of Mr. Rushbaum's presence. And as it relates to the waiver, my understanding is that the waiver was agreed to. I believe it's going to be verbal, Judge, in the sense of not in writing. The written portion of it is the lawyer who consulted with Mr. Adelson. That was because of security issues, is the way that that was dealt with. It was post-conviction. The Department of Corrections housed Mr. Adelson closely managed, and as a result, there was an inability to get to him in a face-to-face conversation. So the waiver issue did occur, and then retention of third-party counsel, we had never believed it to be an issue because of the game plan as it relates to me handling cross-examination and being walled off. And not until the issue that Mr. Ufferman raised did we make that move.
Let's assume for a moment that I find the walling off has been sufficient. Why should Mr. Rushbaum's representation not be terminated at this point?
The motion that Mr. Ufferman has filed is a conflict as it relates to cross-examination. Mr. Adelson, as I understand it, his objection is not to Mr. Rushbaum's continued representation of Ms. Adelson.
Well, your client has a right to effective representation at every single critical stage. I'm also not going to allow any issues basically to get backdoored should there need to be an appeal.
Never came to my mind.
Is there any dispute that Mr. Rushbaum does not meet the elements of Colker?
I don't believe so, Judge, no.
A substantially related representation and a client that is now asserting a non-waiver of a conflict?
Well, also from a practical perspective, this is, as the court mentioned, this has been a known circumstance from the inception. And
It has.
but I think that that cuts both ways in the sense that, and I don't quarrel with the general concept that these circumstances ought to be avoided, and it doesn't create these circumstances. Beyond that, though, there's not been an assertion of this, and of course, Mr. Adelson's entitled to change his mind whenever he wants. He can change his mind 3 hours from now, I suppose.
I will take Mrs. Niles' presence as proof he's changed his mind.
Yes, sir, understood. But I don't think that my understanding from Mr. Ufferman in discussion was that the conflict was strictly limited to Mr. Adelson not wanting Mr. Rushbaum, or potentially by extension myself, to cross-examine. And that was the limit of the conflict, is my understanding.
So why did this legal strategy backfire? Donna's defense planned for these circumstances, yet they did not consider his appeal and his appellant counsel advising him of the risks and changing his mind. These delays are costly, both financially and emotionally, for all involved: the victims' families, the witnesses called, the cost to the court to put the trial together, jury notices, etc. And let's put this waiver aside for a minute. What if Charlie Adelson refuses to testify? What could the court do? Hold him in contempt, fine him, or add time on to his already life sentence, as he is currently in the process of appealing his conviction? Testifying with or without immunity would be a risk for him, and I cannot see how it helps the prosecutor to force Charlie to testify against his mother, because he could change his whole testimony. So my takeaway is that even if you have a verbal or signed previous waiver, the client can change their mind at any time. So isn't it kind of better that it happened now instead of halfway through the trial, potentially risking a mistrial? So what are the consequences going to be? So I'm just going to explain what happened next to save some time. The judge asked Donna Adelson, mother of Charlie, to speak to an independent third-party counsel to satisfy him that she was making an informed consent to waive a conflict of interest. Before agreeing to have Donna agree to her waiver, the judge wanted her to have independent third-party advice. So she met with a counsel that spoke to her about the consequences of waiving your attorney-client privilege, and they met for about 30 minutes. She then decided to agree to waive her attorney-client privilege in open court. The judge asked her these questions, and he found her to be, willing to do that. She also agreed to an unprepared third party to question Charlie. Now, I wasn't pleased about that because, the trial's about to start, and the reason Charlie would be, called to the stand is if the defense gave evidence or an argument. So they've introduced something that the state wants to contradict. So they would bring Charlie back, or, that's what you do with a rebuttal witness. You try to contradict the opposing party's evidence or arguments. So that I don't think was a good idea. The other thing was that she was willing to waive her subsequent appeals. So I don't think that was a good idea either. And the other thing, he had said that she was, very concerned about losing her speedy trial rights, and she definitely didn't want to lose her attorney, Dan Rushbaum. This is done to ensure the client understands the risks and benefits of the proposed course of action. And so this third party counsel must give her all the information that needs to be disclosed to her so that she can make the decision, knowingly. Normally it would be given in writing and or clearly stated on the court record. The judge did confirm this. However, the appellant counsel for Charlie Adelson argued that this is not enough, even if both of them gave waivers, as there is a broader concern of adverse interests. The judge was also concerned about this. So let's listen to what the judge had to say. So before I play that clip, I just want you to have some background information on what's going to happen next so that you can kind of understand what's going on. When a conflict of interest arises, the attorney must ordinarily withdraw from representation unless there is an informed consent, right? Which Donna Adelson gave. However, the adverse interests are conflicts with another client's interests. And that is what's going on here. What Charlie Adelson's appellant counselor was referring to. So the attorney owes a duty to both clients, to both clients, the former client and the attorney's ability to adequately represent the remaining client. So now let's listen to what happens next.
I'm almost scared to speak. Does anyone have anything to raise before we continue forward?
Yes, Judge. May I approach the lectern?
You may.
So, Judge, with the surprise issues of the last couple of days, I have asked for my prior client's waiver again, and with the change of circumstances, he has decided not to give it. So let me be clear, I have a waiver in the past. It's from December 12th, December 13th, and an independent lawyer spoke to him as well, although did not get a signature on the waiver. So we had a waiver. We thought we had a waiver. We didn't think there was an issue. But given the events of the last 2 days, I approached appellate counsel to get a new waiver. Thought that was the right thing to do, obviously, and the cleanest thing to do. And I am not able to obtain that waiver at this point. So as a result, I need to withdraw from the case.
Very well. Does the state wish to be heard concerning the withdrawal of counsel?
I don't think I have anything appropriate to say on the matter, Judge. If Your Honor,
Well
what
put.
we need to do, we would like to proceed, and I'd ask Your Honor to inquire whether we can proceed with second chair representing Ms. Adelson, but obviously we're ready for trial and there's a lot at stake.
Mr. Morris, are you prepared to move through this trial without Mr. Rushbaum?
Judge, I
I tried to think about all of the different potential rabbit trails, and the short answer is I do not believe that I am going to be able to be adequately prepared to proceed forward with the present calendar, primarily because of the division of labor in the case. I would move to continue for a brief period of time. That's also, in speaking with Mr. Ufferman, which is an issue that I'm going to request that we address, the objection by Mr. Adelson would still pertain to my cross-examination, and by extension, the third party would conduct cross-examination. In short, I need time to regroup.
Before we finish today, I will have the in-camera hearing review concerning whether you have been properly walled off. As to the withdrawal of lead counsel, I am going to permit it. The conflict issues are so severe, I believe, to move forward with the trial. Ms. Kappelman, Ms. Dugan would place us in a position where we would end up in a reversal. Let's go ahead and set a case management date. As to all the expense that has been undertaken with moving witnesses and preparing for trial, the state certainly, as a part of any cost of prosecution, if you are successful, may seek those costs as it relates to today, as this continuance will be charged to the defendant. As to a new date, when would the parties like to have a case management?
I think as soon as possible, Judge. I'm prepared to brainstorm with Ms. Kappelman and Ms. Dugan with the state to be able to get a trial date if we wanted to do that. But I don't know if we need additional time. What?
Ms. Dugan advises she has a court date October 15th, so that would be my suggestion.
10:15 at 2:30 will be the follow-up case management to today. Before we go into recess, I am going to conduct the in-camera hearing with Mr. Morris as to any remaining issue of who should conduct the cross-examination of Charles Adelson if called as a witness. If the court reporter can meet me in the jury room, Mr. Morris, please as well.
How did we end up with a continuance today?
Well, I think everyone knew that the conflict existed, or the potential of the conflict. There were waivers in place that seemingly resolved the conflict issue. But as is anyone's right in that circumstance, their consent or their permission was revoked. And as a result, that brought a termination to that game plan, if you will, and necessitated a different one. And that's the reason for the continuance.
And what we really saw was this conflict between Charlie Adelson's desire to have a thorough appeal and his mom in a criminal trial. May not have said that very artfully, but
ultimately the question is whether or not their positions are at odds with one another, and there's absolutely the potential of that, and that's the issue.
Donna Adelson was crying in court, wiping her eyes, and looked very clearly upset. Can you say what was going through her mind, or did she articulate that to you?
I don't know that she articulated what was going through her mind, but I can pretty accurately tell you that you develop a relationship with the lawyer and a connection, the recognition that that connection is going to be broken, and how am I going to go this on my own without you, is absolutely a feeling that a client has, and it's distressing, stressful. The whole situation is stressful in the first instance, but she understands, and put one foot in front of the other and get the case to a jury as quickly as we can. Her desire is for the jury to be able to listen in judgment of the facts and be able to get the case to the jury as quickly as we can.
I know that you just spoke to, she was sad that she can't go to trial, and right now you're upset that you can't get that trial moving quicker, but would you say that this is all kind of for the best in the long run?
I think so. I think that it's going to open up opportunities as it relates to negotiations. I think that it opens up pathways to and exploring different defenses that may not have been previously available. I think that it makes the situation potentially easier and in the best interest of both Mr. Adelson and Mrs. Adelson in terms of having lawyers advocate for them.
You mentioned the word plea. Do you expect that there didn't seem to be a lot of plea negotiations between the parties from the outside, at least?
Oh, you never know.
Let's listen to what the state attorney had to say about a plea deal, and I will leave a link to the full article below.
Mr. Morris mentioned after court on Tuesday that with him taking over as lead counsel and Mr. Rushbaum leaving, that it could open the door to plea negotiations or negotiations with the state.
Sure. Mr. Morris is a great trial attorney. I think if he says that, I look forward to it. Once again, there's a reason why plea negotiations are supposed to be kept confidential, and so I'm not going to speak as to it at all. I can tell you, probably 99% of the cases this office handles are resolved through some type of negotiation. So we're willing to negotiate and talk. Have no fear. Nothing will be done without consultation with the Markel family. So there's nothing secret that will be done. We don't talk about it because, candidly, for negotiations to go back and forth, the law requires it to be confidential on both sides. So if he wants to begin negotiations, I would love to do negotiations. We negotiate on the overwhelming majority of our cases. I look forward to talking to him about it. Once again, Ms. Kappelman will be the point on that, but I'm sure I will be consulted.
So follow my thinking here. The prosecution's theory is that Donna Adelson hated Dan Markel for not allowing her daughter Wendi to relocate with the children to Miami. Yet when Charlie met with Katie after the bump, he was so upset that someone approached his mother. He said, "She has nothing to do with this." There is a police interview where Luis Rivera, the driver, made a plea deal, and in that interview he tells them he thought the hit was for a robbery, and on the day he was told it was for something a lot more sinister. Let's have a listen.
I thought we were going to come in here and rob somebody, So when I get in the car, that's when Garcia told me, "What we coming up here for? Coming here to kill somebody." Told me because I asked him, "Why are you going to kill this guy?" Because the lady wants her 2 kids back. She want full custody of them kids because he had all the custody. That was the plan. That was the deal. That's why we went to go kill that man for.
And how did Tuda know all this?
Katie, I guess Katie told him everything. Katie told him everything. Then that.
But you're just guessing that. You don't know that for sure, do you?
No, that's for sure. For sure, Katie told him everything.
Right. How do you know that? How do you know Katie?
Because he stayed talking to Katie on the phone. Hey, babe, what's going on? Hey, the lady's gonna have. You sure she's gonna have the money on time? Tell her don't play with it because the will go show up in her house. Tell her she better have that fucking money. And he always kept telling her that.
He also said the day before they drove by Dan Markel, that is the victim's house, he said he saw Wendi Adelson walking the children and wondered why was she there. And Katie said she was there to make sure they were up in Tallahassee. And she said it had to be done the next morning because Dan Markel was on a flight that afternoon, which was a Friday, and he was shot in the morning. He also said that the shooter calls Katie to say the job was done, and she said, "I know." And he wondered, how did she know this? She said they would be paid the next day. Watch our video to find out how this all fits together. So in Charlie's trial, Katie decided to tell her story, that she was the go-between and didn't know who the hit was for. Yet in her police interview, originally she said Charlie wanted to hire someone to rough up someone else, but she didn't know that it was for Dan Markel. Is this true? Let's listen to a clip from Luis Rivera's police interview.
Who's fucking hiring me? Like, Katie told me this lady's gonna hire me, but I want you to go with me. Then I hired. They weren't hiring me. They were hiring him.
Right.
So he said, "I'm gonna break you off."
Let's say that Charlie and Wendi were plotting to get Dan Markel roughed up and it all went wrong. Well, in a conspiracy plot to commit one crime, and let's say a more serious crime takes place, well, you're still culpable. And in this video here on the screen, you will hear a story of a driver of a robbery that had gone bad. And the robber, while robbing a restaurant, shot 4 police officers having their breakfast. So check that out if you want to find out how that trial ended. Is it plausible that Charlie will change his story if he testifies to implicate Wendi instead of his mother? Is it plausible that Donna Adelson will try to make a deal, admitting that Wendi did give her a package and she did drop it off to Charlie that night that Dan Markel was shot, but she didn't know what was in the package? In a pre-trial hearing, we heard they found a message between Donna and Charlie. Outside your house. Katie Mae Benoit said she thought Donna Adelson had dropped off some money. So I wonder what a plea deal would look like. Would it be something like obstructing justice? So maybe, getting rid of evidence or falsifying evidence to cover up a crime? Who knows? Maybe she did that with the checks. Maybe she knew Meg Benoit wasn't working there. What about if she pled for accessory after the fact? So, was she helping Charlie after the fact? We'll have to wait and see. What's your thoughts? By leaving a comment, you may help someone else that will read your comment. And of course, I love to read all comments as they are valued, and together we can be more informed. And this information may help you or someone you know. In the meantime, on this channel, you'll find a variety of playlists to suit every curiosity about the justice system. And we provide you with a visual to information and the process. Going through a legal worry is devastating, and the Who Knew and Why Me playlists are designed to help you or someone you know. So please like this video if you like this kind of content. Hit the subscribe button and the notification bell if you want to be notified when I'm going live or upload another video. I'm Karen Cole from Legal Minded Friends. Information is power, meaning if you know something, you can make decisions that are right for you.